and I hope you had a really excellent lunch. And I know the fact that after the lunch we also easily be sleepy. But let me say that our next session is not less important than the morning session. So I would like to proceed the next session with our scholar from Poznan Human Rights Center, Institute of Legal Studies of Polish Academy of Science, Poland, Professor Dr. Roman Wiruszewski. Please join me in welcoming Dr. Wiruszewski, ladies and gentlemen. And for this session, Professor Dr. Prasit Ekabut from the Faculty of Law, Hua Chiao, Chalerm Phakiew University of Thailand, will be taking the role of discussant. And I now send the floor to Professor Dr. Prasit Ekabut.
Good afternoon, ladies and gentlemen. On behalf of the Faculty of Law of Thammasat University and of Hua Chiao University as well, I, as a discussant on this afternoon session, have a great opportunity to express my gratitude for the CPG delegation, including Professor Roman from Poland, who will give you a special conference on universal and regional human rights protection, synergy or rivalry concept that we need to discuss thereafter when he finishes his special lecture this afternoon. Before I give my word to Professor Roman, I would like to encourage you to ask the question from the floor. If you have any questions or any comment, please feel free to raise your hand and go to the microphone and ask the question directly, and need not to have any hesitation to intervene when we are going to discuss on this topic. Thank you very much. I give my word to you. Thank you.
Thank you very much, Professor. And first of all, allow me to express my sincere gratitude to organizers for inviting me to this very enlightening and for me really rewarding exercise. The problem of protection of human rights in your region is not that well known in the European context, so I learned a lot. At the same time, I'm grateful that you decided to accept some contribution from the different part of the world, from the part which is not probably the most advanced in the human rights protection, but still which has developed a lot of quite interesting mechanisms, and I would like to just to present some aspects of the different attitudes of those mechanisms, of the different methods of cooperation. First of all, I'm aware that in this particular region you don't have a workable and stable regional protection, and you are not even many of countries here, including like Singapore, Malaysia, are not even parties to the treaty system of the United Nations. But still, you are part of the kind of a universal system. But I know that the very word universal is controversial, as we know, as you learned. But still, by using universal, I'm not addressing the axiological foundation, but I am addressing rather the formal arrangements of those mechanisms. And in Europe, in fact, we are having four different, at least in the vast part of Europe, not the whole part, but we have four different international mechanisms. Of course, the United Nations system, we have the Council of Europe, we have the OSCE, which is Organization of Security and Cooperation in Europe, which is covering all European countries plus United States and Canada. Plus we have EU, which till very recently has not been that much involved in protection of human rights, but recently became more and more involved and adopted a very profound document like its EU Fundamental Charter for fundamental rights and freedoms, which covers a lot of different human rights. So, you know, we have a surplus of different mechanisms to be used. Does it mean that we are better protected, better off than those who do not have? That is questionable. And I may address some problems which are arising from this situation when so many different mechanisms are functioning, addressing the situation in a country. I wanted to just to address a couple of problems in my presentation and later on in a more extended way in the paper. First, why do we need a regional system? That is the first question, why? The second, what are prerequisites of successful system? What does it mean altogether to a successful regional system? And do we observe synergy between those systems, or is there rivalry? And what are the main challenges of those systems? Of course, you know, as we already discussed, it was assumed after the Second World War that we definitely need international protection of human rights because of drama which occurred during the Second World War, the Holocaust in particular, but also all other genocides and war crimes and crimes against humanity. So we really international, by we I'm referring to the international society, was really desperate to create that kind of system which would at least be able to react. Of course, you know the famous saying "never again." It's a utopia. Of course, this we are always saying "never again," and this again is coming again and again. Like we are speaking right now, hundreds of people are being killed in South Sudan. 1,000 being expelled from their houses. Central Africa is a battleground for very serious human rights violations. So we are nicely set it here, but we should be aware that human rights violations occur in this very moment in many parts of the world. And in spite of all these wonderful and elaborated arrangements. So that failed, this idea. But at least we cannot say that we haven't done anything. By we, I'm still referring to the international community, which I detest this expression, international community, because such phenomenon does not exist, but still we need to address somehow the system. And we also, the declaration was supposed to be a first step, and then we were supposed to adopt quickly legally binding treaties. As you know, it didn't happen. It took almost 20 years. The treaties entered into force, but that was the famous Cold War between communist and democratic countries, and so it stopped the development of the UN system for quite a while. And therefore, in the European democratic countries, very soon realized that they cannot rely on the United Nations as a mechanism to protect and to even to set the standard. So they quickly established their own regional organization, Council of Europe, and in the framework of the Council of Europe, they quickly adopted the European Convention on Human Rights and Freedoms. Why they were able to do it? Because at that time all of them shared certain elementary values. And that is a really prerequisite of any possible successful regional arrangement. To sharing certain basic values. No? One, it's a really democratic society. Of course, we also discuss here what does it mean, democratic society. It's not enough to have a fair electoral system to be real democratic. But we don't need to go too deep into the notion. And nevertheless, it's a system which is based on the rule of law and the division of powers and democratic participation of people in the power. So that was shared by those countries who founded the Council of Europe. And it was a tiny part of Europe at that time. was just at the beginning of 6, the 8, they started to expand. Right now, there are 46 or 7, 40, I guess it's 46. Belarus has been excluded. So right now, all European countries, with the exception of Belarus, are right now members of the state parties to the European, to the Council of Europe and then the European Convention of Human Rights. So it expanded gradually, based on the adoption of countries who were joining step by step those basic principles. I must tell you that when Poland, we were dreaming during the communist time, we were all dreaming how wonderful it would be if we could be a member of the Council of Europe, and if people could address the European Court of Human Rights. So when we were not accepted for quite a while, because we did not have a fully free elections. Our elections in '89, the first partly free elections, were not fully free, because 2/3 of the parliament seats were reserved for Communist Party and its allies. Only one third was eligible for free vote, and all those seats were won by Solidarity. Solidarity also won the whole Senate, but still it was not enough. So we were kept waiting until we had new elections in '91, while other Eastern European countries managed to join the Council area. But at that time, still, the Council was really trying to make sure that countries who are joining are really at least fulfilling formal obligations, having a constitution, having a rule of law, having a protection of human rights. And that was a big dilemma came in '95 when what to do with the Russian Federation. And that time was kind of a rivalry in the European continent between EU and the Council of Europe. Council of Europe started to be afraid that it's losing prestige, and the only way to do it was to absorb the Russian Federation. And of course, the Russian Federation did not fulfill many of the formal requirements. But they said, well, there was a dilemma to keep them waiting and to wait till they fulfill, or to accept them, hoping that while being a member, they will slowly adjust the system to requirements. The second was chosen, and I believe that it proved to be counterproductive, and that, so it slightly lowered the standards of the whole system. Nevertheless, one may ask, what does it mean, effective criteria for the effective control mechanisms of human rights protection? Because, of course, by discussing on the international mechanisms, what are the main goals of this mechanism? To create standards. But standards are really have been, you may say, we almost finished it. We are still, not totally, but we are still developing, as you said today, a new convention of disability, convention recently, and we may think of new other conventions that may come, but as such, standard setting has been achieved both at the universal level in particular, but also in the regional level, I'm referring to Europe, has been more or less achieved. So standard setting is in a way achieved. The second goal is to monitoring. Monitoring, I believe, it's absolutely right now perfect. We never can tell right now that we will be shocked by some new wave of violence, because we knew very well. We knew very well what will happen in South Sudan, we knew very well what will happen in Central Africa, so it's not that we didn't know. Because we know right now it's almost impossible to hide something, and the whole system of monitoring is such a rich one that when I'm always saying that the bell is always ringing, but there are not enough answers to the ring. That is a problem. So we now have standards, we are able to monitor those standards, but we are not able to first to prevent violations, and we do not have also effective mechanism of reaction. At the United Nations level, this reaction is built on the system. There are, as you know, two different sort of pillars of that system. One is so-called treaty system. We have 9 major treaties, 9 treaty bodies. They are examining reports, proposing different remedies, different proposals are making, and waiting for an effect which sometimes comes, more often do not come. And then we have the other system. It's the political one based on the Council, Human Rights Council. Human Rights Council has some achievement. I must say that I was rather skeptical because I had a chance to work with the United Nations system during the Yugoslavia conflict from 92 to 98, and I was really frustrated by the totally powerless of that system, and this was not able to do anything. Practically, the only thing which we have made was just to provide humanitarian assistance, nothing else. The war stopped when American bombed, and that was the only way to stop that particular war. And before that, we couldn't do anything almost. And we could perhaps, but we didn't want. We didn't want to be more active. So I was skeptical about the creation of the council. But right now, even based on our seminar here, I learned, for example, that in case of Singapore, in case of Malaysia, also in case of even Poland, I realized that UPR, the system which has been created, which I, as a former member of the Human Rights Committee, was also afraid, because the treaty bodies were afraid that the UPR system will diminish the role of country reports to the treaty bodies. But in fact, I don't think so that is the case right now. The UPR is also relying on opinions of treaty bodies, and so in a way, it's. I think that it may even streamline a bit these mechanisms, this monitoring mechanism with the UN system by having this UPR. However, the big problem of the big challenge, in fact, for the UN system is the fact that there are too many bodies. You know, if you are a country, and let's face one thing, every single country in the world is at least party to one of those 9 treaties. So that is for sure. So we may say that it covers all world. But if you are a country who's ratified all of them, not that many, but there are, then you have to report, and you are reporting every 4 years. You have to prepare in 1 year 2 reports, which is absolutely impossible if you want to do it meaningful. It's impossible, simply, technically. If those reports are to be real ones. So it creates a big problem. One, and also this mechanism, the other mechanism, which is individual complaints, are being dealt by too many different treaty bodies. So that is this idea proposed by Professor Manfred Nowak and Professor Manfred Schein. They are proposing the establishment of the World Human Rights Court. And that, it sounds a bit like a utopian project, but I guess that it may gain. It was supported a couple of years ago by what was her name? Former High Commissioner for Human Rights, the Canadian lady. Yes, Louise Arbour. Yes, Louise Arbour, precisely. She was in favor of doing that. Right now, but there was no political support, meaningful political support. But well, you know how these ideas are developed. You put them and you wait, and maybe I hope that maybe in still my lifetime. That may be exaggeration, but too optimistic perhaps. But this type of development may occur because we may need kind of this type of court also at the United Nations level. Now, when looking to the European system, so the success of this was based on the fact that it provided efficient enforcement mechanism. And you got the judgment of the court, and that judgment is supposed to be implemented. Of course, not 100%. There are still, for political reasons, several countries were reluctant to accept. That Turkey for many years rejected the decision of the European Court to compensate for expropriation people from Cyprus, northern Cyprus. Russian Federation, for example, is always refusing to, in cases of Chechnya, they are accepting judgment and paying compensation, but always refusing to investigate perpetrators who committed the crime and who committed they are saying no, they don't and there is also no method, not how to force the country to implement. So the judgment has a solid legal foundation, but still does not have a total enforcement mechanism. Of course, in the EU system, it's better because if you are an EU country and if you don't implement the judgment of the European Human Rights Court, which is not EU court, it's Court of the Council, but still EU can really force you to implement that decision as well. So in my country, for example, we really do not have a big choice, and we are really trying to implement those judgments as much as possible. But because the idea of regional system is that it is, as I said, sharing axiological foundations means by accepting the human dignity. It's a foundation of all human rights. So there is a principle of equality and non-discrimination, and there is principle of freedom as such. And question of success is based on the acceptance of those basic elements. However, it's this system is also, as I said, slightly diminished, and the effectiveness slightly diminished by the fact that because of the idea to expand it into the whole European continent, not all state parties are fulfilling the obligation as such. Now, another problem is how to, what should be the role of the court? Is the court just only implementing the law, which is the European Convention plus, of course, additional protocols, or is it interpreting it as a living document? And of course, in the human rights, you cannot adopt the first approach. You have to accept the convention as being a living document. There was for example, the very recent, in fact, just this year, the decision of the Human Rights Court in case against Greece, when Greece in 2008 adopted a law which allows for registration of heterosexual couples, not the marriage but registration as a civil liaison for heterosexual couple, but refused to accept the same legal system for homosexual couple. And the court, European Court, in a couple of months, this was taking a couple of months, it shows you because the case was lasting for 3 years. That's also one of the problems of the system. It took too long. But the court said no, it violates principle of non-discrimination, Article 14, plus right to privacy. Because in the European context, you cannot base your claim only on violation of discrimination clause. You have to link it with some other substantial right. So they link it to Article 8, right to privacy, and say no, you are violated because even if the founders of the European system did not think at that time of allowing the registration of homosexual couples, right now the situation has changed, and the European society has changed, and therefore it's a living document. So unlike the judge in the Singapore case, they said, well, we believe that it is that far that we should, in European context, we accept that is a rule which should have been applied. Therefore, you violated the convention. So that it shows how the European court is understanding, and that is also element of success. However, the other problem is the reaction of both systems. Now, I have been a member of the Human Rights Committee, and I have been also an ad hoc judge in the European Court of Human Rights. So I I know the kind of a tension between those two systems. During my time, my tenure as a member of the committee, at the beginning, it was end of 90s, there was kind of a silent understanding that we are not even mentioning any judgment of the regional system, either American or European, or even we are not supposed to mention other treaty bodies. The Human Rights Committee was only applying ICCPR, and we are referring on this, and we couldn't care less about what others were doing in the same type of situations. But that was impossible to maintain. And I was already surprised when I came that they were adopting this, and slowly we started to change this. Slowly we started to look what other treaty bodies were doing, and slowly we started to also to look what the European Court was doing, and trying to adopt similar approaches. Because if you are in a situation in one country, you have two conflicting decisions of two different international bodies, you are undermining the system. Because that was a country who said, well, sorry, we don't know which one we should accept, so we will go our own way. And it happened very rarely, because as you know, there is a system that you are not supposed to go with the same claim to two different or to more than one international procedure, but there are always ways to avoid it. And that was what happened recently in a case of Singh versus France, when Mr. Singh is a Sikh, and he was refused to take a photo for his ID with his turban. And France said, no, we don't allow to head to be covered. You have to leave it. And he lost all his cases in France, and he went to the Strasbourg, and he lost. Strasbourg said, well, Strasbourg in that situation is losing so-called the margin of appreciation rule. That we leave the country. We leave to the country decision how to rule about this particular aspect. So France decided that they need it, let them do it like this. And he went, the same Mr. Singh went to the Human Rights Court, not for the ID, but for the driving license. Because he couldn't go for the ID, because that was all he did with ID, he did against France in Strasbourg, so he went to Geneva with driving license. And Strasbourg said, sorry, you violated freedom of religion because, why? Because you didn't explain why. That is a big difference between UN system and the European system. In the European system, they can use margin of appreciation because still those countries are more homogeneous, and they know that that this margin would not be that different between countries. In the UN context, if you would start to use margin of appreciation, you would have totally different standards all over the world. So the UN is never accepting margin of appreciation, and say, listen, you can possibly reject the situation in which your head is covered, but you have to explain why. Why you are? What is the reason? You cannot say that it creates a problem with identification, because the people are using all the time. It may problem with identification if they will take it off, because normally they are having them on. So what is the reason? And of course, the Human Rights Committee was right. There was no really good reason to reject because it comes on the top of your head. It absolutely does not in any way hinder identification of the face. So in fact, probably the European Court decision was more based on some other reasons, but they didn't want to tell it. So they said, well, just a marginal appreciation. And the Human Rights Court said, no, it is violation of religious right. So, and what to do now? What can France do about that? France can, so far, France said nothing about that. And in the UN system, you have only one way of follow-up. You have one member of the Human Rights Committee who is insisting, he's sending letters, meeting ambassador, and trying to push for reaction and for explanation how the decision will be implemented. But that's the end. Of course, later, if they will still be not willing to accept, then the case that probably will be reported to the Human Rights Council. The Human Rights Council, during the next UPR exercise with France, will raise the same that particular issue. And that's the only way how we can, how the UN system can push for that. But the problem was that France may say, well, sorry, but we are following the European court rule. So there is a conflict, so we decided to follow the European rather than the UN. And that, of course, as I said, is extremely counterproductive and dangerous. I don't think that there will be many cases like this. There will be few. In my time, we had some cases against Portugal ruled differently from, but that was really exceptionally. What I see right now, also in the Strasbourg, that the Strasbourg is trying to be more proactive in this particular sense, and we had a very interesting, I will discuss this in a more detailed level, this problem when it comes to the right to the freedom of religion, when the Human Rights European Court is really giving a more protection to the freedom. For example, in case against Poland, the prisoner was refused to obtain food according to his religion, and he won the case in Strasbourg. And immediately the prison regulation were changed in Poland. Right now, if you claim to have a religious requirement for certain food, you will be provided, unless it's extremely difficult. But there are no very difficult regulation of this. Requirements of this. So that when again we had recent cases of against United Kingdom of wearing a cross by member of the British Airways, and the other one was by nurse. And in both cases, they won against United Kingdom. The European Court said, no, you are violated, because you did not say why it impedes the activity to what extent, and so the court is trying to be more forthcoming. On the other hand, there was one bad, I would say, one strange case against Italy, when the lawyer she was the Judaism believer, and she didn't want to be present during Sabbath on the court, and she asked for changing of the date, and they refused to change. But the court said, well, they tried to accommodate you, and you could have made a replacement for your presence, so it was not violation. I believe that that court in this particular case was maybe not prudent enough, but generally speaking, I see the development of the Human Rights Court in this particular area of religious freedom in a rather positive way. Of course, the problem with the regional system is that, in a way, there are too big expectations for it. In particular in eastern part of Europe, whenever something goes, people are saying, "Oh, I will go to Strasbourg. I will go to Strasbourg." So there are thousands of cases going to Strasbourg. You wait for the decisions for many years. 4 years is the rule. So it's not really an efficient individual remedy. It's rather, I would say, more active popularity in that sense. It's changing the system, and it's for that sense it's effective. But our main problem is what to do with our relation with the UN system. Because some people say, well, let's forget about the UN as such. We have our regional. We don't need the UN as a whole. But that is a big mistake, because the UN system without active participation of the European state would be meaningless. We have to be there. We have to actively participate in the system and be active actors. Because otherwise, the system will also lose its importance. So, I believe that there is a time. we are in the process of slowly of modifying the European system. There are new rules which have been proposed to make it quicker, to make it more efficient. But a lot depends also on the attitude of judges themselves. And I can see that there is a tendency for them to be more interested in the United Nations system. In the UN, on the other hand, the UN is also facing very difficult challenges. The main being an effective implementation of its different type of decision, be UPR, concluding observations, being decisions in the individual cases. So without that, the mechanism will not be able to fulfill its hope. Is it possible to create such an ideal international system which will fulfill all our expectations? Means having wonderful standards, having a full-fledged monitoring, and having a perfect reaction, even prevention. Of course, the best is to prevent. But if we cannot prevent, at least can we possibly react? I doubt. At that stage of international relations, as we see it, I certainly doubt. And for example, I was stunned by references quite often made during this conference to sovereignty clause. We abandoned this many years ago. It depends how you define sovereignty. But if the sovereignty it's understood as a totally freedom from any international pressure, that is of course wrong, because we accepted the human rights. We accept that the human rights is concern for all of us. If something is going wrong in Thailand, as you know right now, it's also my problem. It's not just a problem of Thai citizens. So, and we should be aware of that. I believe that this problem is somehow being understood better and better in at least in my country and in the European context. That I believe should be a kind of guidance for our future activities in the area. I believe that we should be aware that we never will reach the beautiful horizon, but all our efforts aiming at moving our work more smoothly, it's probably will be rewarding. Just my few comments concerning this. I'm aware that it's not easy to, in a short presentation, to present all complexities of the relations between different systems in European context. It will be fascinating, for example, to see how the EU is right now reacting, and we have a judgment of the famous CADI decision. What is it called? The European Court, not the EU Court in Luxembourg ruled that the Security Council decision should not be implemented. The Security Council on the sanctions against Mr. Kadi because it violates EU law. And then we have, come on, how far we can go? Whatever Security Council the decision was supposed to be a cornerstone for the international law. And all of a sudden, a regional organization saying, no, sorry, you violate our principles, our human rights principles. It reminds the famous German Solange. So Germans also say, well, we accept the international system as long as it provides not lower standards that we are having in our own constitution. So this type of development is also very interesting, but of course it's, I don't want to go into details because we don't have a time and space for it. Anyhow, thank you for your attention right now, and I'm ready to have an interesting discussion on this.
So thank you very much, Professor Roman, for your excellent presentation regarding to the challenging problem of human rights law today. Because human rights law today have a lot of problems in terms of implementation and in terms of enforcement. Law without enforcement is can't be considered as law because it may be considered as a moral obligation or ethic obligation rather than law. How UN mechanism can be efficiency, can be efficient in terms of the law enforcement. How can we strengthen human rights implementation or enforcement measures on behalf of the UN? Do UN have the right to protect on behalf of the UN people, to intervene in the domestic affair of the state when state violate human rights by its own soldier, by its own policemen against the innocent people, or the problem, not only in the problem of the political right, but it includes as well for the problem of poverty, the poor people. How many people die without food, without rice, without water? These problems are the problem of the world today. And I think that we have a lot of many conventions on behalf of the UN. We have a lot of international agreement. We have a lot of protocol, a lot of international instruments, including regional convention that we call regional human rights law. But the value of interpretation, it is going to the same direction as Professor Roman tried to explain to us. Do we interpret human rights value in the same way, or do we reserve our own interpretation according to our belief or according to our religions? So religion question is quite a difficult thing to harmonize different concept among different religions belief, because Muslim people do believe that they have the right to take a hair look like that, and once you take photography on ID card, they don't want to take out. And French regulation, as Professor Roman did explain to us, did require that all Muslim people who live in French territory need to follow that kind of regulation. Do that kind of regulation violate human rights law or UN value concept or universal concept of human rights law or not? And who can implement this kind of law against French authority? This is a big problem. Once French is one nation in the UNSC, French authority has the right to use their veto right according to Article 27 of the UN Charter of 1945. We understand very well, even though that article did not mention any word about veto right, but by interpretation of Article 27, voting power of the UNSC, UN Security Council, we understand very well that only 5 nations in this world has the right to use its own veto right. I think that we have a lot of questions from the floor as well, not only my comment, and I would like to give your right to speak right now in order to convey some message to the Professor Professor Roman. Thank you very much. Have any questions to ask to Professor? Anyone may have, or any comment, please? Yes, thank you.
Thanks very much, Professor Roman, for that very detailed and interesting talk. If we're talking about implementation, there's one thing which it's not exactly to do with what you were talking about, but I wonder if it factors into it, which is whether people have the capacity to make claims about rights and whether those capacities are being eroded or diminished. And certainly in the UK they are. So there's lots of human rights legislation in the UK, but all the public institutions which have been places where people could go to gain advice and to push forward certain things, they've all been cut. So the average person will have absolutely no cognition about how to pursue their rights in any kind of legal or formal sense, and they don't have any money to do it, and there's no place they can go to pursue it. So I just wondered if we're talking about implementation, whether people's actual, material ability to make claims, right, if that's something which we need to factor in.
Comment rather than questions, I think.
But I may just share some comments. Yes, of course, you have to. But implementation is a very broad concept. Implementation is when the country is fulfilling its international obligations. We ratified International Covenant on Economic, Social, Cultural Rights. There are certain standards and rules the country is supposed to do its utmost. Not necessarily already fulfill all possible high standard, but do its utmost to achieve those goals which have been presented in this particular treaty. There is implementation. Of course, then what I have been raising the question of giving an individual chance to react if he or she is being her or his right has been violated. That is a different matter. Almost the human rights have been protected by the country. That is the principal rule. If we are talking about international system, international is always subsidiary. Always. The only question is how far is subsidiary, how we can subsidize the lack of reaction from the national governments, how far we can subsidize. In certain cases, we can easily, in this political and civil rights, it's easier. Even the question of money, it's not an issue as such, more question of knowledge. But then you have a lot of NGOs. Why? It was interesting. Why, for example, India never ratified optional protocol to the ICCPR, and then also I discussed with Justice Bakwati, who was my colleague from the Human Rights Committee. I said, listen, that would be drama. If the India would ratify it, we would be overflooded by thousands of complaints, because they have an excellent lawyers, and they have a really network of lawyers reaching even very poor. So they would start immediately to use this, and we would drown. So our system is not ready for such a flood of possible complaints. So sometimes it's not a question of the poor people cannot avoid if they would have a chance. But I mean that for me the efficient and the effective system would be if I would see that the results of these adopted standards are being seen on the ground, and then we see that, and you can see, for example, really, when I look into the report of countries who are coming before the Human Rights Committee, you really saw the progress made by of course, sometimes small, sometimes regress. Well, it's another issue. But as a rule, you see a small progress which has been made. But we cannot expect miracles from that particular system. Such I don't have an illusion that whatever arrangement which we made, or even the word call, whatever, it will not solve the most dramatic part. It can only help those countries who are already trying to improve this. So, for example, just in my country, as I already mentioned to some, you would have never abolished death penalty if not because of the European Convention and Protocol 6 to the Convention, which requires from us to abolish it. So there was an external pressure, and if you wanted to be a good European country, it was unpopular. It was against the majority of my population. And the same goes for many other aspects, the controversial aspect. We need this external, and sometimes even the government, who is willing to do something, is afraid of the social reaction. So listen, we may not be happy with that, but we have to. We have to do this non-discrimination based on sexual orientation. We have to do disabled rights. We have to do age people right now. I'm happy that this discrimination based on age is also because I reached the part in my life and I'm counting on not being discriminated based on age. So it's an effect of external pressure and willingness and necessity to be seen as a reliable partner of international relations.
Thank you very much. I have one question to ask you about the regional and also universal logistics value. I mentioned ASEAN again. Yes, ASEAN before. ASEAN is also ratifying many of the international law, but however, they also plan to draft another convention, ASEAN Convention, for example, Women Convention, Thailand Convention. We as the ASEAN people, we concerned at this point very much because from our experience we can see that the ASEAN value is also lower than the international value. So in case that the ASEAN have their own convention or instrument and lower than the international standard, what is your suggestion for all of us as ASEAN people to solve this problem or to implement that kind of the convention that built by our government?
As I'm doing my research on ASEAN law, I think that ASEAN is quite different from EU in terms of the human rights protection, in terms of the trade liberalization, in terms of social development. Is quite different. Even though ASEAN try to imitate the structure of EU in order to develop our ASEAN community as we expect in the year next 2 or 3 years, 2015, we will have ASEAN community. Inside ASEAN community, we will have ASEAN economic community. We will have ASEAN social and political community, and we have another community relating to the social development as well. In that, and political development as well, political and security council. Even though we try to develop ASEAN in this direction in order to have the same spirit as the one community for all 10 nations as a member of ASEAN today. Thailand is one of the members of ASEAN, we know. And we would like to explain to you that even though we have a high ambition like that, until now we still have a lot of problems in terms of implementation, our ambitions, our expectation in the year of 2015. Only one aspect in terms of economic development aspect might be possible in the year of 2015, that ASEAN Economic Community will be realized, will be implemented in the few years, because right now many custom duty are 0% already for 10 member states, and except for CRMV, Cambodia, Laos, Myanmar, and Vietnam, they have the special right of derogation. They need not to reduce their tariff or to eliminate their trade obstruction to other ASEAN state members. So we give toleration to the CRMV nation in order to let them have the chance to develop their country, even though they need a time lag to develop their country. ASEAN would like to have another ambition in terms of human rights protection as well. But in order to have such efficiency mechanism of human rights protection among ASEAN states, I think that ASEAN leaders right now need to discuss in detail how to elaborate ASEAN Convention on Human Rights Protection. I think that ASEAN needs to have an ASEAN Charter of Human Rights like that in order to protect human rights human rights amongst ASEAN people. We do need not only convention, we need to have ASEAN Human Rights Court as European Court of Human Rights as well. But in order to setting up this court, it's not easy at all because we have 10 nations who are member states of the ASEAN. We interpret human rights in different ways. Indonesians interpret different human rights already according to their own Pancasila principle, according to the Allah doctrine. They have Muslim principle. They try to reserve their right to interpret human rights. So while Myanmar, we have a lot of problems with them because they did not accept Rohingya people as Myanmar people. That while many Rohingya people became both people and they escaped to Thailand, and not only Thailand, Malaysia, Indonesia, and try to go to the Western country as well to be a refugee. I think that this is a big problem and big responsibility of us in member states as well in order to respect human rights law. And we cannot discriminate its own citizens, or its own minority group amongst the different states in ASEAN. Thailand and Myanmar, we have a minority group a lot along the frontier line. You will see that this is a big problem of the ASEAN in order to have a convention to protect human rights of minority group as well. We cannot conclude treaty with Myanmar in order to ignore their right. And the problem of stateless person, you know that there are a lot of people right now have no nationality. And they are working as a worker in Bangkok, in rural area in Thailand. It became a lot of problem in next generation when their children were born, when they married with Thai or other ethnic group. How's about the human rights protection for them? I think that this is a crisis for ASEAN country to develop our human rights protection as soon as possible and try to follow the same value of the UN. I think that somehow the fundamental freedom of human rights, fundamental human rights protection according to the UN Declaration of Human Rights of 1948 must be a core inner of legal corpus or juris corpus of human rights that must be implemented as soon as possible. Fundamental rights of people should be recognized and must be protected by international treaty, and not only that, by domestic law as well. Because without domestic law, how can we have a guarantee or a good guarantee for the people? I think that this is the weak point of human rights implementation, because many nations doesn't have enough good law in terms of the human rights protection. For example, forced disappearance of people in Thailand, we did not have such law yet in our Thai criminal code. Or crime against humanity, we didn't have such offense in our code of criminal code or penal code. We didn't have such crime. I think that it's time right now for Thailand to modify or to amend our law, criminal or penal code of Thailand, in order to have a special court, in order to have a special sanction against the grave breach of crime against humanity. Such we have an example in the Rome Statutes. We have 4 offenses according to the Rome Statute. As you know, genocide offense, war crime offense, crime against humanity offense, and crime of aggressions. That we need to have that kind of law as well. Without law, without court, specific court, human rights violation will continue. And I think that we need to have a lot of debate. Maybe quite good to Professor Roman to make it clear. Maybe we will have another topic, human rights in Thailand. For this moment, I would like to hear your feedback a little bit before we close. Some.
Thank you. As you probably realize, the European Court of Human Rights actually has more international visibility in terms of its decisions than decisions coming out of the UN system. Both the UN system and the European system were slow to develop, slow to get a caseload, cautious, so that in the early decisions of the European Commission and Court, there was frequent decisions of margin of appreciation in which states were given a fair amount of leeway. And one can look back on that and say, well, that, of course, this was a new system. It was probably wise to ease into it carefully and not to be too pushy too quickly. But the European Court has been perceived internationally as tremendously successful. With the two questions, one is in relation to the expansion of membership in the Council of Europe. All member states get to name a judge, and therefore the panel of judges has expanded quite dramatically over time as the adherence to the treaty has expanded. Many people feared that this would have a conservative effect on the court. And I wonder what your assessment is as to whether expansion has changed the court in any way, more conservative or more cautious or simply more burdened with work. My second question is, looking at the European system, we see defiance by Russia of some of the decisions of the European Court of Human Rights. I wonder if you could give us some idea as to the degree of non-compliance with judgments that have come through the system in Europe.
Okay, thank you very much for this question. And thank you, Professor, for answering your question. Of course, I mean, UN standard should be seen as a kind of a standard which has to be adopted. And in fact, in many kinds of transition, for example, when we adopted our constitution, we took literally international conventions, both the UN and the European one. And then we took out of them to incorporate the constitution. And then, of course, not all of them were immediately implemented, but they were seen as a goal to be achieved. As far as your question concerning the extension effect, as has been done some research on it, that, but of course it's not always known precisely which judge precisely, of course we know who voted for, who voted against. My assessment is that unfortunately the whole system, when we created a permanent Court of Human Rights, it was, a colleague of mine, Elizabeth Palm, she, the famous Swedish judge, she used to be a judge in the European Court before the changes of this Protocol 11 and after that. So I told her, well, it was better right now that you have a permanent court, so I presume that you have a better working condition. She told me, listen, it's not true. When we did not have permanent court, the court was working only on sessions. First of all, the prominent Western European judges could afford to be at the bench, because they could leave from the court and so come here for the session. if there is a permanence, they have to quit. And of course, for French, German, Spanish Supreme Court judges, much more prestigious to be in the national Supreme Court than to be in the European Court. So we lost a bit of prominence as far as the Western European judges are concerned. And as far as the Eastern European, they were a very strange situation. You found a lot of unexperienced people who were not that much even legally minded, because some governments, I'm not saying that all of them, but some governments were sort of awarding the supporters, and so the level was lower. And on top of it, she told me, listen, when we are on session, we are working like madmen. When you are working all the time, you tend to come at 10, leave at 2, have lunch, and this and that. So in fact, we worked better than but that's just anecdote. In fact, I believe that there is you can see, definitely for me, one element is clear, that they are right now more relying on the marginal appreciation. And many new judges are afraid of being too strict. They would rather leave this marginal appreciation for countries to also, because they know that in their own legal system they are not implementing this in a very precise manner. So it's, as a result, you may say that, I don't know, it's more conservative or less. That is difficult to say. And sometimes you never know. No, we have a very famous, I mean, many of you have heard of this Lao Tzu the decision. Was this case of cross in the school room. And Lao Tzu was in Italy. She was Italian. She was a lady from Finland who became an Italian citizen, and she complained that the cross is being on display in the classroom. And she won in the first, it's not like 7-0 in the first chamber. 7 judges said no, the display of the court violates the neutrality of the freedom of consciousness and freedom and the neutrality of the state, because it shows that the state is sort of based on Christian values. And then she went to the Grand Chamber, and the Grand Chamber was 15-2 against her. So we can count 15 judges who believe that there was violation. That was okay for the state to display the cross, and 9 judges believe that it's not. And if there will be another composition of the chamber, this will be different. So, but it's normal. I mean, in such a controversial situation, there is always like this. You never, famous saying, in a court you like the sea, you know, always in the hand of God. So you never know what will be the reaction of the court. Like I was explaining to a couple of you this famous cutting case of Poland that we lost unexpectedly. And so I believe that there is the extension definitely may be a little lower because the level of explanation sometimes of justifying it's such poor one. It's such a non-convincing. That is my concern sometimes. Okay, I can accept the ruling provided that I'm giving a reason, a good reason, a legal reason, but sometimes they are not given. So that is perhaps, but it's not a question of because lawyers who are working for them, because judges are also writing on their own judgments. I believe that the extension definitely may be, but on the other hand, I hope that it will again. The new wave of lawyers coming to the chamber that may happen. And then the second question was about level of enforcement. That is, as a rule, I think every country wants, because the moment they want to, but there are sometimes situations if for political or ideological reasons they simply refuse, and there is no way to push them. With Turkey, the Council of Europe was able to push for implementation of this Louisa Lu decision to pay compensation for the lady who lost her house in the northern Turkey, only because the Turkey was involved in disputes of the agreement with EU. And EU put one of the conditions to implement all Human Rights Court, European Human Rights Court decisions. So Turkey accepted that. in terms of, when you deal with Russia, what we can do? They say, no, we pay compensation, we will not investigate who murdered this particular person. We don't have capacity to investigate, because of course they were officers of the Russian army and they don't want to do it. There is no way how we can fulfill them. Sometimes this implementation is just not a real one. When the famous case of Tyson versus Poland, when the lady was refused to undertake abortion, and Poland was supposed to introduce a system in which a person can claim legitimate abortion. Poland established such a system; it's absolutely not working. And what? And the Council of Ministers of the Council of Europe, who is in charge of follow-up to these, and it's powerless. He's saying, well, we have to change. Yeah, we have to change. We are working on it, and we are working on it for years. So, but the level is low. I would say that percentage-wise, I don't have numbers, but once I remember a couple of years ago, we did kind of an analysis with my students, and it came out that more or less 20% of judgments were not fully implemented. There were more, which was partly implemented, but about 20% of the judgments were not fully implemented by countries. And of course, I mean, the most famous one is Article 6, right to due process and prolongation of our trials, which Poland is losing permanently, and we are unable to change the system. It's so slow that we are losing one by one. So you may say it's not implemented, because it's not enough to implement to pay the compensation. Implement will be only if you change the system. So there will be not the same claims again, because the system is for that. It should be loss of a case by state should be a warning signal that something is wrong. You pay compensation and you do something which will prevent the same case to come back again. But if you are having again, means that that is not efficient. Thank you.
So let's give our speakers a nice big hand. Thank you, Professor Dr. Roman Yurushevsky and Professor Dr. Pratik Ekabun for a really insightful discussion. And now, ladies and gentlemen, we're going to have a 15-minute break for the coffee. You are all welcome to the little meal and coffee right behind you. Thank you.